Morning, everybody. It is 8 o'clock on this beautiful Wednesday morning, and we are going to get started. One second. Gotta shut my office door so you don't hear the craziness in the office. Well, good morning. It is presentation day for me. I'm very excited to be talking today about mastering residential leases. My name is Sam Saad, and we are going to talk about how to fill out the Florida Realtor, Florida Bar leases produced by the Florida Supreme Court today. These are useful forms in your practice. And of course, because I am an attorney, we're going to start out with a disclaimer that I'm providing you advice, but it's not legal advice that you can rely on in your practice without talking to me first separately. It's a little bit about me, of course. I serve on the FAR Bar and NABOR drafting committees for the contracts that you use. My office litigates leases. We do deposit disputes. We do evictions. We do all the things related to commercial and residential leasing. So we have a lot of experience on the topic today. Um, of course, I have a title company, so if you have any closing needs, you can always reach out to me separately. Give me a call on my cell phone, and we'll get you closed. So today we're going to talk a little bit about the rules for leasing for realtors, and we'll talk about a couple of the forms generally, and then we're going to dive into the two main leases that are produced by the Florida Supreme Court for your use in your practice. So let's start off a little bit about some of the rules that you have to follow as a realtor filling out a lease. Pretty similar to contracts. Um, in terms of the sales, you have to use the approved forms. I'll tell you that the forms are produced by the Florida Supreme Court. They're not produced by Florida Realtors or the Florida Bar Association. Um, they're produced in conjunction with these organizations, but they are state approved forms produced by the Supreme Court. And your role is limited to filling in the blanks. So the typical to the sales contract and listing agreements that you're used to using, you got to fill in the blanks. There are a few more blanks than maybe you're used to from the contract, and they get a little complicated. We'll go into all those. Your role is as the scrivener. You should not be giving legal advice, explaining legal effect of things that are discussed in the lease, and you should not be modifying or creating any custom leases or writing addenda. There are really no addenda provided by the Supreme Court, just the lease forms and the statutes, and we'll dig into those. Couple other thoughts. The lease that you're allowed to draft as a realtor must be for 1 year or less. So you can have a 365-day lease, but not a 366-day lease, as I like to joke. So just be careful about that when you're filling out the form to get the dates correct. Two thoughts. I get a lot of questions about, can I be a property manager and my broker won't let me handle deposits? The short answer is you may be a property manager without a brokerage attached to your business, but you cannot engage in leasing activities under Chapter 475. If you are going to handle deposits, if you're going to sign leases, if you're going to list the property for lease in the MLS, that's all licenses are required for all those activities. If you're changing light bulbs, if you're changing air filters, if you're acting as a handyman, that's property management, and there's no license requirement for that. Just don't enter into the lease. One other thought, of course, this is Florida. We have a lot of service members down here, and we thank them for all they do to keep us safe and free. They have special rules for service members in Florida. First of all, if you get an application from a service member, you have 7 days to approve or deny them. If you do not approve or deny them within 7 days, they are approved. If you have an association, a cooperative or a homeowner association or a condominium association, and that entity requires approval of leases, which all of them do pretty much, they only have 7 days to give our service members an approval or a denial. And if they don't, then they are approved and you must lease to them. And you'll notice here, provision number 3, you cannot waive or change this. This is not something to be contracted out of. If you're dealing with a service member, you have 7 days to get them approved or deny them, or you must lease to them. This is not negotiable. There are a few disclosures that you need to fill out when you're doing leases. First off, and I'm going to go into this one in a little bit greater detail when we get into the forms, but I'll zoom in on it so you can see it here. This is the non-lawyer disclosure. It's a
Can I
pretty
ask a
simple
question?
form. You just put your name in here 5 times, and then the landlord or tenant signals that they can read English or cannot read English, and but that the lease was explained to them, and then you and the landlord or tenant sign it. Pretty simple. And I'll get into that in a little bit greater detail in the forms. Up next is the flood disclosure. So if you've been on any of my other webinars about the sales contract, you've seen this form before. This one is specific to leases, and it just says, instead of seller, it says landlord. You must provide this at or before the rental agreement is signed. Um, the disclosure, let me sit from the screen so you can see it better. The disclosure is pretty standard. If you've done sales contracts, either the landlord has or has no knowledge of any flooding that has damaged the unit, the landlord has or has not filed an insurance claim, and the landlord has or has not received assistance for flood damage to the unit. And I'll point this out that flooding does not mean the upstairs neighbor leaked into the downstairs unit. It's hurricane flooding, tidal flooding, rain flooding, sustained periods of standing water from rainfall, overflow of inland or tidal waters, that's the sea coming in over the land, or flooding that you're used to from a river, stream, or drainage ditch, or from an established water source. So it's not upstairs unit flooding into the downstairs unit or pipe breaking. It is hurricane or storm related flooding. But you do need to fill this out with every single lease. So the Supreme Court has approved 2 lease forms, and you need to pay attention to the top of the form when you're filling these out, because if you fill out the wrong form, you're going to have a bunch of extra language. If you're doing a single family and you fill out the condo form, or you're not going to have enough language if you fill out the uh, uh, condo form for the single family. So be very careful. So you notice on the screen here, you've got 2 headings, and I'll zoom in on those when we get to the forms. And then the other thing is the Supreme Court has attached the entire Landlord Tenant Act to the lease to make sure that you have all of the required disclosures that are in the act. And that's a fairly simple way to do it, and it's a very effective way so that the tenant and the landlord both know exactly what's expected of them under the law. So now if you give me a moment, I'm going to stop the share and I'm going to switch over to the forms themselves. And then we're going to take a deep dive into those. Okay. Just give me one moment. Everyone can see the non-lawyer disclosure on the screen.
Yes.
I see heads shaking. Thank you, Tina. All right, so this is the non-lawyer disclosure that we just zoomed in on a moment ago. If you are preparing the lease for landlord and tenant, you need 2 of these. one for each. And again, it's fairly simple. You put your name in all of these blanks. There are 5 of them. 5 times you write your name. The tenant or landlord signs off that they can read English or that they cannot read English and that someone read this lease to them. The landlord or tenant signs, you sign as licensee, and notice it's not the broker, you sign as licensee. And again, this is produced by the Supreme Court of the state of Florida, so they mean it. All right, so this is the lease. Let me zoom out so you can see page 1 in total, and then we'll zoom in and go through all the blanks. So this is the first page of the lease. You'll see you got a lot of work to do. Let's dig in. Make sure it looks right on the screen. Okay. All right, we have a couple of questions here, but let me answer some of your questions real fast before I start on the lease terms. So, Michael, you were asked about 7 days each or 7 days total. It is 7 days each. Are the disclosures required for 12 months or more leases only? Also required? Yes, Tanya, you need the disclosure for both short and long-term leases. Michael, you were asking if you can write an option into a lease for future years. If you want to write an option into a lease, Michael, you can do that. Just make sure an attorney does it for you because a lease purchase option can get very complicated very fast. And then if the landlord wants to do their own lease, Noreen, you can certainly, the landlord and tenant can always do their own lease, but when you want to be involved, you need to use this form. So let's talk about this form. It is the apartment or unit in a multifamily housing situation, including a mobile home, condominium, or cooperative for a term not to exceed 1 year. So this is the form for condos and co-ops and mobile homes. And you'll note throughout both forms that there is a blanks with a parentheses around them. Don't leave those blanks blank. That's where choices or decisions have to be made in the lease. Noreen, if you want to do a lease for 1 year and 1 day, you would need a lawyer for that. All right. So it's real simple on this lease. To start off, it's the terms of the parties. This lease for a period of, put the number of months in the first blank here. So a 3-month lease, 6-month lease, 12-month lease. It won't be more than 12. When does it start? You put the start date here, you put the end date here, and then you put the landlord in this blank and the name of the tenants in this blank here. Now, if you've got a long landlord name, and for those of you who've been on my other webinars, you've heard me talk about how to properly name things for like trusts or to use the full legal name of the LLC. You may need to create a separate form, a separate piece of paper, a Word document, and put the full and complete landlord name on that. You know, if it's Sam J. Saad III, trustee of the Sam J. Saad III Revocable Living Trust, dated, you know, whatever. You want to put that in there, in here. If it doesn't fit, then put it on a separate piece of paper and just put, you know, Sam J. Saad III, trustee, with an asterisk next to it, and then go to the separate page. Same thing for tenants. When you've got multiple tenants, separate them with a comma. If you've got, you know, 4 parties and they're not going to fit on the line, use a separate piece of paper and put an asterisk next to it. Okay, we're going to talk more about electronic delivery of documents, so don't get it confused. Here, in the middle of the page here, you're going to put the landlord and tenant's email address and telephone number. But this is not enough information for the parties to use for electronic delivery of notices. And when I get to the statutes at the end, we'll talk about the electronic delivery of notices. And that's going to be very, very important to your customers because they want to send an email. They don't want to do a notice and post on the door. And unfortunately, that's what you're going to have to do if you're not careful. All right, so this is the parties and the term of the lease. Up next is the property rented. The landlord leases to tenant apartment or unit number. Put the unit number here. In the building located at, put the property address here. So this is where you put the street address of the building. And then you put the name of the association in this blank, which you can get from the property appraiser's website, usually in the legal description. Then you put the city, the zip code, and any furniture that's going to be going with the property. Um, be as specific as possible and attach a list of furniture if needed. I don't want you, if you represent the landlord, to have to go back to your landlord and say, hey, the tenant took that lamp in the living room. They said it was theirs. And then the landlord's mad at you for not having the lamp on the furniture list. So be very careful about that. For short-term rentals, I'm going to tell you right now, I would not use these forms. You can use these forms. They will work for short-term rentals. But if you have things like a fully furnished apartment and 6 people coming in for the weekend, this is going to get a little cumbersome. But for your regular old-fashioned leases, 6 months, a year, 3 months, and it's just a couple, this is going to work just fine. Note that you're admonished to write none if there are no furniture and appliances, so don't leave this blank. You want to avoid confusion. Okay, up next, the tenant has permission to use the pool, the common areas, the tennis courts, the pickleball courts. And again, this lease being designed for multifamily properties, usually there are common areas. And then up next is the rent and the rental charges. This is a kind of a long section here, so we'll go through this, deposits and rents. And basically you put the amount of the monthly rent here. And that goes in this blank. When is it due? Week or month? Typically, the rental installment period is monthly. However, it can be weekly. For short-term rentals, usually you pay the entire amount up front or break it into a couple of payments. Again, this lease doesn't contemplate that scenario, but you can use it for that. Tanya, you're asking if you can use an attorney prepared lease for short-term rentals. You absolutely can use a lease prepared by an attorney for any of these things. Remember, on leases in Florida under 6 months, you're going to pay taxes. You're going to pay sales tax and tourist development taxes. So you need to know how to calculate those. Tourist development tax varies by jurisdiction. The state sales tax is 6%, but there could be a local option of a penny, which is another 1% sales tax on top of that. You might have heard about the penny option or the 1% option. Those are local taxes on top of the sales tax and in addition to the tourist development tax. So you're going to put the amount of the tax, 6% plus TDC plus local option in this blank here. And then the total amount of taxes and rent goes here. And if the taxes change, the tenant owes the difference. And then, the tenant does not get a choice to how they pick. They pay by cash, check, or money order. When we get to the single family lease, you'll see you get to choose some other options. Noreen, you're asking what are the current taxes? Noreen, it depends on your jurisdiction. Collier County is 11%. I think Lee County is 11%, but there may be some local option taxes in some of the communities in Lee County. So you'll need to research that question or contact me separately.
The county is 11.5%.
11.5. Good. Thank you, Tina.
Mm-hmm.
Okay. So unless this box is checked, the lease payments must be paid in advance beginning on, you put the date when the first lease payment is due. And then these blanks here that I'm highlighting here, these are for prorations. If the tenancy starts, if the lease starts in the middle of the month and you want to prorate to the first of the month or the 15th of the month, then you would put the proration, the first date the rent starts through the last date of the proration and how much is due and when it's due goes here. Then we get into all the charges. So the tenant owes a security deposit. They could owe advanced rent for a certain rental period, depending on how you charge for the rent. They could owe a pet deposit. There could be a late charge that you put. Normally, this is not more than $25 or $50 for each lease payment made more than, and then put the number of days they have to make the rent payment. Typically, it's 3 days to get the rent in, but some people put zero and they want to do on the first and it's late on the second. So that's it. That is allowed. If there's a bad check fee that you're going to charge, I strongly suggest charging a bad check fee because that's a pain in the butt for the landlord and you to chase down new money, get a new check, get cash, and you're allowed to charge $20 or 5% of the lease payment. So put what you're going to put your charge here, and then you can make all payments in cash if you miss a lease payment or you bounce check. Okay. So the security deposit, you have to be very careful with the security deposit and advanced rents in Florida. It must be kept in a separate non-interest bearing account, or if it is going to be in an interest bearing account, then you have to pay interest to the tenant. So most landlords don't want to mess with that, so they just do a non-interest bearing savings account in Florida and hold the money separately. You cannot commingle the deposit with the rent funds. So your landlord really needs two bank accounts to get this set up correctly. One to hold the deposit and the advanced rent, and the other to receive checks for the monthly rental payments. Otherwise, the landlord can post a bond, which costs money and is a waste of time. I've never seen this done, but it is an option. If you have 5 or more rental units, then you have additional rental lease requirements that we're not going to get into today, but just be aware that if your landlord has 5 or more units, you are working more in the commercial realm and you need to be aware of that. Okay, the notices provision, notice in the notices provision, that was supposed to be funny. The notice and notices provision that you put your name as landlord agent if you want to receive notices for the landlord. If you're the property manager, you put that information here and your business address goes here. Otherwise, you can leave it blank or put the landlord's information in there. You have rights to perform inspections for the landlord. And then notice here, all notices to landlord shall be by certified mail or hand delivery to landlord or landlord's agent, except there is a new statute that we're going to go over here towards the end of this section where you can now do electronic notices. So be mindful of that. And you can post on the door of the property if the tenant is absent from the property when you go there to post a notice or to give a notice. Oh, Jeff, I apologize. I didn't see your comment. Did they change the law on interest collected? No, I don't know if they changed the law, Jeff, but you have to share the interest with the tenant. All right. Up next, the use of the premises. This is a residential lease. The tenant agrees to obey all laws. The landlord has to give you have to give a copy of any restrictions. So I would give the rules and regulations of the association to the tenant as a part of the leasing process. Just have those rules and regulations handy and turn them over to the tenant so they know what they're allowed to do, how they schedule golf, pickleball, all that stuff. Um, Notice that the tenant is also subject to all the rules of the association. This is very important when a tenant wants to be unruly and the association sends the landlord a notice. The landlord sends the notice to the tenant and the tenant has to follow it, or you can evict the tenant. You are allowed casual overnight guests, but if they stay more than the association allows, you're going to be in trouble. So be very careful about checking with the association for how long overnight guests can stay. And then the landlord is required, approval is required for anyone staying longer. Okay. You are allowed pets if the box is checked. You are allowed smoking if the box is checked. If either of these boxes are not checked, no pets, no smoking. Unless, of course, you pay the deposit, the pet deposit. Simple things, you can't keep flammable items, environmental hazardous, destroy the property. These are obvious and basic, but they're in the lease. No alterations or improvements. Note here, this is a very important box. Um, Landlords, especially on short-term rentals, don't like having holes punched in the wall for pictures. So if you check that box, the tenant will not be allowed to hang pictures. So I think this is a pretty important box for landlords who don't want their property destroyed. Make sure that you check the box or the tenant can hang pictures and window treatments. Michael, you're asking if you're on the hook for the balance of the lease. I have a whole separate seminar, Michael, on what happens in evictions and what the tenant has to pay. But just the short answer is yes, they're on the hook for the balance of the lease in certain circumstances. Okay, maintenance of the premises. The landlord and tenant agree that the maintenance shall be performed by the person indicated below. And we'll talk, and you have to check the boxes here for whether the landlord or the tenant is going to pay for each one of these things as they come due. Now, typically in your short-term rentals, you're going to check landlord for all of these if you're using this lease for the short-term rentals. But again, for most short-term rentals, you're going to want a different lease. For longer term, 6 months to a year leases in a condominium or co-op, you check who's responsible for what. Right here, garbage removal. This one is typically a tenant responsibility. This one is vague. It says air conditioning. I might write in down here on a lease longer than a few months, or I'm sorry, right here. Make sure that the filters are changed. I see a lot of problems with people with air conditioning filters not being changed, and then the air conditioning goes out, and the tenant gets upset, and the landlord gets upset, and they pay a bunch of money, and the HVAC company changes the filters. So be very careful about that one. Just something I've noticed in my 20 plus years doing this. Change the air filters. Okay. The tenant is not required to do any major replacement of any equipment. The landlord is responsible for major repairs. Major maintenance is defined in this lease as anything that costs more than what you put in this blank. And notice there's no default, so don't leave this blank. Could be $100, could be $75, could be $500. But again, it's going to be commensurate with the lease. On a short-term rental, might be $50. On a longer-term lease, like a year, it might be $500. Okay. If there is an issue where the tenant has to evacuate for extermination, the tenant does not have to pay rent, but the landlord is not liable for damages. I think this is pretty important for landlords. They can move the tenants out to exterminate pests, but they are not liable for damages. Except that if the landlord is negligent or commits a wrongful act, then they are liable. Moving right along, utilities. So utilities, the tenant is responsible for all utilities except for what you put in this blank here. Again, on short-term rentals, you're probably just going to put that the landlord pays all utilities because you're not going to want to spend the time to change the utilities for short-term rentals. You'll just charge commensurate with that. Service members, we talked about that. You must give proper notice, and tenants have special rights for termination where they can terminate if they're a service member and they get deployed. Again, I want to take a second to just say thank you to all those people, given what's going on in the world today. They're doing a great job keeping us safe. I really appreciate them. I have a brother-in-law who served, and it's really, really interesting to talk to him. Landlords' access to the premises. This is a big one for tenants and landlords. When can the landlord come into the property? They may enter the property for preservation and protection purposes at any time. After reasonable notice for purposes of making repairs. What is a reasonable notice? Well, that's a tough one, but basically, if you give 24 hours notice, I think you're okay. You can come into the property with the tenant's consent for emergencies, or if the tenant unreasonably withholds consent, or if the tenant is gone for more than, say, 2 weeks in a 1 month rental period. There are certain things the landlord cannot do, and that's self-help. I get a lot of questions by landlords about, can I change the locks? No, you cannot. Can I take the door off? No, you cannot. Can I take the windows off? No, you cannot. You must evict. If the tenant doesn't pay, you evict. You do not engage in self-help because that is a separate tort where the tenant could sue the landlord for punitive damages. That's going to get really expensive really fast for the landlord. So no self-help. Casualty damage, the tenant can terminate after 30 days if the property is destroyed. The tenant can vacate if it's unusable a portion of the premises, then they can reduce the rent. This is another great way to get into an eviction lawsuit. So make sure that you, if you're the landlord, are on top of your property. Make sure that you fix any problems right away to avoid the tenant moving out or claiming damage under the 7-day notice provision. If you don't fulfill your responsibility under the lease, or if there is a default, the statute is detailed. Again, we talk about this in my other presentation on defaults that my associate Gary Green puts on. That's on my YouTube channel if you want to see that. And then unless this box is checked here, the tenant may not assign the lease. If I'm a landlord, I will never check this box because I want to see who is the tenant and I want to make sure the proper tenant is approved. Mona, you should say who should pay for bed bugs. That would be the tenant would pay for bed bugs. If they're in the bed, that's the tenant's problem. Risk of loss. Landlord is not liable unless the landlord is negligent or commits a willful act. So if the tenant gets robbed, that's the tenant's problem. And then other notes, the lease is subordinate to any mortgage. So if the landlord gets foreclosed on, the tenant's going to get evicted by the bank, and there's nothing the tenant can do about that. If the tenant does work on the property, they can't put a lien on the property. The contractor cannot put a lien on the property because it's in the lease. I will say this, though. The provisions in Chapter 713 for notice of lease work are very, very interesting. And I don't think that this lien language holds up without a proper notice of this term in the public record. So be careful about that. Not going to be an issue in condos and short-term rentals and leases for less than a year, but just be mindful of that problem. There's very likely to be an approval contingency by the association. So check the box here for who pays for the association approval. And then If there's a security deposit due by the association, you want to make sure that the tenant is paying that, not the landlord, to keep the tenant obvious. Noreen, I'm going to get into the Landlord Tenant Act. It's attached to this form by the Florida Supreme Court, so we'll get into that in a minute. Lead-based paint, of course, if you're renting a property prior to not those built prior to 1978, and you are familiar with this, then I'm going to zoom out so you can see it a little better. This is the lead-based paint acknowledgement, where the lessor discloses that they know of lead-based paint, or they have no knowledge of lead-based paint, and that they have provided any available records on lead-based paint. And then the tenant acknowledges that they've received copies or received the pamphlet, which you are to provide as the realtor. And then you acknowledge that you're aware of your responsibilities. Note that you, the realtor, you initial here, and then the agent, you, the realtor, you have to sign. Don't forget to sign your signature. And if there's two agents, the landlord's agent and tenant's agent, you both have to sign this. This is the lease that you're signing, so be very careful about that. Okay, let me zoom back in. If you get into a situation where there is a lawsuit, the winner gets their attorney's fees paid by the loser in the lawsuit. So the landlord and tenant have that in their favor or as a hindrance. Be very careful about that as well, because attorney's fees provision is a two-edged sword. And then time is of the essence. You know, from my sales contract presentations, when time is of the essence, you cannot miss the deadline. If the rent is due on the first and late on the third, and you pay on the fourth, you breach the lease. And time was of the essence. I argue that that might cause the lease to terminate, so be very careful there. The lease is binding on the benefits of the heirs, personal representatives, successors, and assigns of the landlord and the tenant. So if either party dies, then their families pick up and the tenant can stay, or the tenant's estate has to continue paying on the lease. There is an integration and merger clause in this lease. What does that mean for you, the realtor? Everything that you put in the MLS is not included in the lease. So if there's something in the MLS that's supposed to be in the lease, make sure you write it into the lease on an addendum and have an attorney do it. You would sue in the county where the property is located. So if you've got a tenant from up north who wants to sue in New York under New York law, that's not going to work. It's under Florida law. Both parties agree to act in good faith, so no being sneaky. You get some tenants that want to sneak a relative in. You get some landlords that want to hide mold. Just be very careful because you agree to act in good faith. You've got the radon gas notice that's required by state law. And then you've got this provision on personal property. Tenant must initial in this box for the following provision to apply. If you are a landlord, you will demand that the tenant initial this box to save yourself a lot of money if they breach the lease and leave a bunch of crap in the property. Pardon my French. If they leave a bunch of stuff in the property, you don't want to have to give them notice and then save it and preserve it. So have the tenant check this, initial this box, and then you can just throw away everything if they leave it there. Then you've got the signatures of the landlord and the tenant. You date, landlord and the tenant, and you date the lease, and now your lease is signed, executed, and ready to go. Next, you're going to fill in who prepared the lease. Typically, this will be you or me, the attorney. If you, as the agent, help fill them out, put your information in here. If I did it, put my information in there if I helped you. Okay. Very important. I'm going to zoom out a little bit so you can see this a little better. Very important page. After the tenant and landlord have executed the lease, they may agree on an early termination fee if the tenant wants to get out early. So when you're signing the lease, this is a separate agreement. It's an addendum. It's an opportunity for the tenant to pay a fee not to exceed 2 months' rent and get out. So either the tenant and landlord agree or they do not agree to liquidated damages and an early termination fee. So the way this works is tenant and landlord have signed the lease, they've signed this early termination fee addendum, and the tenant wants to go home, go leave early, go back north, they get a new job, they get transferred, whatever it is. Um, the tenant pays the amount in this blank here, and then the lease is over, and that's it. They get their security deposit back if they have not damaged the property. If they have damaged the property, you go through the proper security deposit, notice provisions, which we talked about in my other video, and you're good to go. So this in total that we've just gone over is the multifamily condominium lease produced by the Supreme Court. Now, the Florida Supreme Court, in addition to the lease itself, has included all of Chapter 83, Part 2, which is the Florida Residential Landlord and Tenant Act, in the lease. So you'll notice over here, you can see my mouse pointing to the side of the screen, we're only on page 9 of 21 of the lease. There are still 12 more pages of statutes attached to this lease that your tenant and landlord need to be aware of. And we're going to go over a few sections today, but I just want you to see and be aware that the entire Landlord Tenant Act is attached to the lease and the parties are subject to it. Now, the provisions that I want to point out to you in this presentation relate to filling out the lease form. If you want to talk about evictions and other things, then refer to my other video on landlord tenant law with attorney Gary Green. So first I want to point out the deposit. The deposit language that is required in all Florida leases that where a deposit is paid is right here on the screen in front of you. And you just need, if you're doing your own lease, which you should not do, or if your customer is doing the lease and you're going to facilitate the signing so you don't practice law without a license, admonish your customer they need to have this provision in the lease. It's the all caps language, and it's the deposit warning to tenants regarding the treatment of the deposit. So copy and paste that and put it into your lease if you do your own. Up next, and this is probably the more important one, new statute. You'll notice here came out in 2025. It is the electronic notice statute. And if you read through this, and you'll see that you need to take from where my mouse is here, all of this needs to be copied into an addendum if you want to make right here. All of that needs to be copied into an addendum if you want to allow for electronic notices. As an alternative to copying and pasting out of the statute, if you shoot me a text or an email, I've already made one for you and I'll give it to you. But you need, if you want to do electronic notices, then you've got boxes that have to be checked. You have to make sure the email addresses are properly listed. And you have to check the boxes for the landlord and the tenant. There are two elections here, landlord election, tenant election, and you need both, and you need both email addresses in the lease so that everybody knows exactly who to email and what to do. All right. That is the multifamily condominium lease produced by the Florida Supreme Court. Before I switch over to the single family lease, does anybody have any questions on the multifamily lease? You can unmute yourself or put it in the chat. Anybody
Is the
questions?
5 properties that they own, are they all in one complex or just 5 in the state of Florida?
It's 5 in the same entity, so it'd have to be the same landlord.
Okay, but it's
So if
5
you,
total, not just one person that owns 5 in a particular community, it's 5 anywhere in the state.
5 anywhere in the state, but it's by the landlord, Michael. So if you've got a smart landlord, they've got each property in its own LLC for asset protection purposes. Then
Sure.
that landlord only owns one. If you've got some large multifamily operator with more than 5 in one entity, then those provisions would kick in.
Okay, thank you.
So
Yes, Tina.
you talked about the tenant can bail out and pay the 2 months earlier if they want to leave.
Correct.
But how about the opposite? How about if the owner is selling the house, the property?
The landlord in this form does not have an opportunity to terminate the lease. They would
Okay.
sell subject to the lease, and the new buyer would take subject to the tenant's lease as well.
Okay.
On a provision, what we call a kickout provision, you need to have me draft it for you separately.
Yeah.
Okay.
Sam, this is
Yes,
Mona.
Mona. Good morning.
When did that flood addendum came by?
Which one?
The flood notice that you have to
The
sign.
flood disclosure, you have to fill that out for every lease.
Yeah, when did it come by?
Few years.
It's been a couple of years, maybe 2 years since they did the flood disclosures, Mona.
Yeah. Yeah.
Okay, do I have to go back and do one for once I did without?
No, just on a go forward basis. But if you did a lease in the last 2 years without a flood disclosure, you probably made a little boo-boo, but that's okay.
All right.
There's no penalty other than they can terminate the lease until they sign it. So they can get out of it until they take well, I should say this, on the sales contract, they can terminate if they don't have a flood disclosure until they close. It's a little less clear what would happen if they didn't get the notice on a lease. But
Okay.
it is in the statute, so you should do it.
Yeah, and something else about the 7-day approval. Some of the HOA requires 1 month to approve.
That's a special statute, though, for service members, Mona, and the association has to follow it, or the association must allow the rental. So that's for service members only. If you're in the military and you apply, you must note. If you say you're the listing agent and you've got a lease and you sign up a naval officer, you would go to the association. You would say, "Association, please be advised. This is a service member. You have less than 7 days to approve." And the association must approve or deny within 7 days, or it's an automatic approval.
Thank you.
Yep.
Good
Leslie, you got a
morning,
question?
good morning, Sam. Sorry, it's Leslie.
How are you?
Good, how are you? When a tenant, when the home is for sale, they have to honor the lease for the tenant?
The buyer of the property must honor the lease and let the tenant stay.
Let the tenant.
Yeah. So if you're asking about the seller's obligations, the seller must give notice of you check the box there in the sales contract for the property is subject to lease.
Yeah.
And then the tenant gets to stay. And if the buyer wants to view the property, like a showing, you've got to get the tenant's permission to show it, and you got to follow that section I showed you earlier about the.
So they have to honor the lease. The new buyer. He can't
buyer
tell
must honor the lease. That's right.
Because I'm buying the house. Okay.
Yep.
Thank you.
You got it. Other questions about the multifamily lease?
Yeah, how far in advance can you write a lease?
In advance, like if you were due for like next year or something, you mean? Yeah, you could go in as far in advance as you wanted. There's no prohibition. Like if you put the start date here and the end date here on the lease, they can be whenever, as long as they're a year or less apart. But if
So
you
if
say
somebody
you want to
wanted,
make
so these can't be more than 1 year, I get that. So if they wanted 3 years, they could write 3 separate 1-year leases in effect in 27, 28, et cetera.
you could do that. I don't see a problem with that. As a matter of fact, I've read that is the way to handle it. You would do a new lease.
Talking about the 1-year limit, that's only if a realtor is involved. But
Right. A tenant and a landlord can agree to a 10-year lease, or a lawyer could write a 10-year lease, whatever you want. But realtors are limited to 1 year or less.
all right, thank you.
That's by statute. Amy?
So I'm sorry. I have a tenant actually, it's coming due, a lease. It's a yearly lease, obviously. So you're saying the better advice is to write another lease because he wants to renew. He already told me.
No, Leslie. Michael
Okay.
was asking if he wanted to try and get around the 1 year provision by having 3 1 year leases. If you're already in a lease, just do an extension. It's very simple.
Got it. But with an addendum.
An
Just do
addendum.
an
Or
addendum.
well, it wouldn't be an addendum, it would be an extension. An amendment. It'd be an amendment to the lease, an extension.
Okay. Amendment to lease. All right. Thank
Yep. Amy, I think you unmuted. You had a question?
Yes. So you just mentioned an extension. Is that a different document?
There's no forms. You would need a lawyer or to draft or the parties to draft an extension agreement. It'd just be an amendment to lease. It can be very simple that just says landlord and tenant hereby agree to extend the lease for an additional 12 months or whatever it is. But there's no forms for leases other than these forms that we're going over right here. There's no like addenda like there are for sales contracts. So everything has to be custom made.
Okay. So my question was, so this document, I had a landlord and a tenant do a 1 year lease with this document. And what I think they did was they used a new one of these, or I don't know, I think they highlighted it or did white out, and they did a 2 year lease.
Well, again, the landlord and the tenant can enter into a lease for as long as they want. It's
Okay,
only
but
the
they used
realtor
mine.
that can't. Only when the realtor's involved can it not be for a year or more.
Okay, but Sam, they used my sheet. Like
Well,
do you
that's
see
fine,
this
but
page you have?
they did it themselves. Were you
Yeah.
involved in that?
No.
Yeah, then they're
No, they
fine.
pretty much told me that they had a 2 year lease, and I said, you didn't have a 2 year lease. Your lease is expiring. And then they sent me a picture image of this,
That's
and from
fine.
what it, okay.
Two
Making sure.
parties can agree to whatever they want. It's just the prohibition is just making sure the reason for the 1 year limitation to realtors is to make sure that you don't get somebody into a long-term, very expensive lease that they're not aware of or prepared for. It's a consumer protection thing for them against realtors. But two parties could enter into a 10-year lease if they wanted to. They could white out the blank right here after you fill it in for 1 year and change it to 50 years. That's not a realtor thing. That's a landlord tenant thing.
Okay, but another question now, Amy kind of opened up a can of worms. How do we get compensated as realtors? We just don't, right? We just get
No,
compensated
you're
one time.
allowed for 1 year.
That's it. Okay.
So if you draft an extension,
Uh-huh.
if you negotiate an extension, you would want a new listing agreement of some kind that says that you're doing the extension for them so that you get
Right.
paid for the additional
Get paid again.
work that you did.
Right,
Well,
right.
Leslie, I was gonna say, the original listing agreement does state that they have
Yeah,
to
any
pay a certain
extensions.
amount. So when they sent me a picture of that, I let the landlord know that she owed me some money, and she sent me a check.
Yeah, and
Good,
that is very possible because I believe the listing agreements say any extensions.
It
Okay.
does. It
Yeah,
does.
the lease listed, the FAR bar lease listing, or the Florida Realtors, not FAR bar, it's Florida Realtors. Lease listing allows for extensions, so you would be protected there, Leslie.
Okay.
All right, let's dive into the single family lease. Oh wait, Aaron, you had a question? Let me see. Oh, we kind of answered that, Aaron. You can always do an extension other than a formal lease. You can do a simple extension. Okay, let's look at the single family lease. Again, you've got your non-lawyer disclosure. You put your name 5 times and the landlord or tenant sign it and you sign it. Okay, notice residential lease for single family home or duplex for a term not to exceed 1 year. This is the single family lease. It looks a little different than the multifamily lease. Again, you've got your obligations under the act are attached to the lease. That's the Landlord Tenant Act we talked about. You put your name and address of the property owner here. You put your tenant name here. Again, with the email address and the phone numbers of the parties, but this is not sufficient for electronic notice purposes. You need the addendum. You put the street address of the property you're leasing here. Don't forget the zip code. And then again, list the furniture and appliances, or none if none are provided. You'll notice there's a lot less blanks here. The typical thought on a single family lease, it's going to be for longer. Now, of course, you can do short-term rentals. They can be fully furnished. I would do an inventory to make sure nothing gets stolen. That's, to me, that's very important to protect your landlord. But I would do an inventory if you're doing a long-term lease, or I mean, not a short-term rental, and it's fully furnished. You can put the additional people who are not responsible for the rent in this blank here. That's the kids usually. And then this is a lease for a term not to exceed 12 months. We've talked about that. Noreen, all these forms are available on Form Simplicity, or they're actually available on the internet if you just Google them, because they're produced by the Supreme Court. But you put the it's not to exceed 12 months. You put the start date. You put the end date. Then you put your rent charges, and you'll notice it's a different layout and it's a much longer layout than the condo lease. You put the total amount of the rent, not including the taxes, in this blank here at the top of the screen. This is the total amount of the rent excluding taxes. You put whether it's paid in installments or paid in full, and then you put whether it's paid monthly or weekly. If it is paid monthly, this blank here, highlighting here, the purple here, this is the monthly rent. This is what you're used to doing in a typical monthly lease, where someone's going to pay, $1,500, $2,000, whatever it is a month. This is the blank where it goes, right here. Oops. Okay, if they're gonna pay a weekly rental, you put when it's due in the first of the week, and the amount of the weekly rental goes here. Or if they're paying in full, like for a short-term rental where they pay the entire amount up front, that amount would go in this blank here. And then you put the taxes that are due on the lease in this blank here. So if you've got if you've got a full, they're paying the full amount of a 3-month rental, and it's $1,000 or $10,000 a month for the rental, that's $30,000. What's the tax on $30,000? That number goes right here. And then they either pay it with each rental installment, or they pay it in full at the time they sign the lease. And I'll tell you the answer to the question as to which box you check, if it's this box or this box up here, depends on how much is being paid and when it's being paid. If they're paying the full amount of the rent up front, then you check this box over here, right here, and the money is due to the state within 20 days after the end of the month in which the rent is collected. So think about that. It's 20 days after the end of the month in which the rent is collected. So you got a 3-month rental for season. What month are we in? We're in July. So say in August, you get a seasonal rental for 3 months in the 2027 season. Someone's going to be there January through March of 2027, but they pay all 3 months in August of 26. The landlord owes the sales and use taxes in September of 26. So you need to collect all that up front and pay it all to the state when it's collected. And then you've got, if it's paid in installments, you put the total amount including taxes here. If it's paid in full, you put the total amount paid here. And then you put where the rent is to be paid. It goes to the landlord, unless you as the agent are collecting it for the landlord, or your brokerage is collecting it for the landlord, because as an agent, you would never collect rent and put it in your account. It always would go to the broker's escrow account, or to the landlord directly. And then you've got the prorations. We did this on the multifamily lease. It's the same. You put the prorated amounts and dates in here. Now, this lease allows for you to choose how the rent is paid, whether it's by cash, personal check, money order, cashier's check, or something else. A lot of tenants like to pay by Venmo these days. A lot of landlords like to get paid by Venmo these days. If you're going to do Venmo, you check this box right here that I'm highlighting in red, and you put the service in the blank here that I'm pointing out. So if it's a Venmo or a cash app or something other than cash or a check or a money order, write it into this blank. ETF, electronic funds transfer, I mean EFT, electronic funds transfer, you'd write EFT right here.
Quick question
Yes, Amy.
before you go forward, because I'm going to forget. That you said to not that if it's a short term, so you're talking about short term with this one, but you said if you use a short term, you don't have to use this
No,
lease.
no. The length of the lease is not important for the form. It's the type of property. This lease is for single family homes. What I suggest is if you're doing a lot of short-term rentals of furnished property, that you do not use these leases. You get a custom lease from a lawyer, me. But if you are doing regular annual rentals or 6-month leases, and it's not a complicated lease, then you can use this form. If you're doing like a 3-month short-term rental and they don't want to pay for a lawyer, you can use this form. It will work. It's just there's a lot of nuances to it. Okay. So
Okay, Sam,
yes, Tina.
what's the cost of you to do this form for a?
We charge 1 hour of my time, $545.
Okay, thank you.
Yeah. Money due prior to occupancy. So when the tenant signs the lease, they're going to pay a sum of money to the landlord at the beginning. Usually it's first, last, and security. It may be other things. If there's a pet deposit, if there's an HOA deposit, if there's other things, you would put those all in these blanks on the screen here, and you put the total due at signing in this blank right here. So who receives the money, at what address is it paid, first month's rent, prorated rent, last month's rent, security deposit, pet deposit, homeowner deposit, all that goes in these blanks. You get your pet deposit right here. Now, if the tenant is late, they can be charged a fine, usually $35, $50 a month. It can be up to 4% of the rent. And it's for so many days late. Usually you put 3 days here. I've seen 1 day. The default is 5 if you leave it blank. I think that's too long. Got to get that rent in because the landlord's probably on a mortgage payment. Pets and smoking, again, like the other lease, no smoking, no pets unless the boxes are checked. Notices, the landlord's agent. This is where your name goes if you are helping the landlord collect rent or do notice provisions. Otherwise, you check the box here and the landlord receives their own notices. Okay. Notice in this single family lease, again, the tenant pays all utilities like the multifamily lease, except for something that the association would provide. You put that here, or that the landlord provides. You put that here. And then notice here, again, a lot more choices than the multifamily lease as to who fixes what. And you check the box, landlord or tenant, depending on who's paying what for each one of these. Now, normally the landlord's going to pay for pretty much everything except for things like right here. See the red I'm highlighting? The filters. Normally the tenant would pay for filters. That's and then everything else I think is pretty much negotiable. And then again, the tenant may not assign the lease unless you check this box. This lease, you pick the number of keys that are given. And if there's any homeowner association control devices, like a key fob or a scanner to get in through the gate, you put all that information in this section of the lease, and then you get that returned to the landlord, or you can charge the tenant for it if they don't do it. With that, again, you've got lead-based paint for pre-1978 properties, and you as the agent signed this lease as well. And that is all the differences of the single family versus condominium lease. And then the statutes attach again. You can see they all attach. I did not highlight them in this one. Any questions about the single family lease? And let me look at the chat. Amanda, you're saying agent or landlord responsible for paying the taxes after the 1 month period. The landlord is the landlord liability. Noreen, if the landlord's doing their own lease, you don't need to put that in the MLS because I don't think the tenant really cares. But you might put that in the listing agreement, landlord to provide their own lease form. You might put that in your listing agreement. Other questions about leases? Before I have one more document to show you, but I want to make sure I answer any questions you have at this point. Janine?
Yes. What if you have a signed lease and then the tenant says they're not moving forward and they haven't put monies down yet? But say you get another tenant that is willing to move forward, and how to protect yourself so you make sure you don't have two active leases.
So you would need to terminate the first lease. If the tenant is not agreeable to termination in a formal way, then you would just give them notice of breach of lease for failing to take possession and pay the deposits. And then, of course, time is of the essence. So the lease would be terminated, and then you could enter into the new lease after you've given notice of termination for failure to perform.
Okay.
Again, that's not something you would do as a realtor. That is 100% something that the landlord needs an attorney to do for them.
Okay. I may
You
have
you don't want to be giving default notices to tenants.
Okay.
And then have the tenant come after you for unlicensed practice of law, because I've seen that happen.
I may have her reach out to you then, the landlord.
Yeah, just have him give us a call. Gary Green in my office is the attorney that handles landlord tenant matters. He's very good. There's usually flat fees. We don't charge a lot.
Okay. Thank you.
Sure. Gerard, you had a question?
Yeah, just a quick one. On all those Florida laws that are at the tail end of the lease itself,
yes, sir.
They have all the little boxes. Do all those boxes need to be checked and initialed by, or is that just
No. If you wanted to provide the electronic notices like I was showing you, if you wanted to provide this notice, you would copy and paste this section out of the statute into a Word document, and then you would need to see here, like if I can see where my cursor is, you see where it says name in the parentheses. You would need to fill this in with the proper names and email addresses, and then check the appropriate boxes. So you would not just fill in the statute, you copy and paste into a Word document and make an addendum.
But I mean, when you're writing that lease, that's all of those laws that are put in there. They don't need to be signed. They're just part of the
They're
lease.
just part of the lease. It's nothing. When you sign the lease, you sign up for the statute. So when they sign here, landlord and tenant sign here. Yep. It says that the statute is included as a part of the lease. I'll have to find where it says that to show it to you, but it says it right in the lease here.
All right, no problem there. I'm just curious if they needed to initial all that remaining stuff that's at the back end. No,
they don't need to initial all those. They do. You'll notice that the pages need to be initialed. Each page, all 21 pages need to be initialed, but you wouldn't need to fill out in the form in the statute itself. You wouldn't need to fill anything. You just initial the bottom of each page.
Oh, okay. That was basically my question. If those pages...
you would initial each page. It's a part of the lease. The statute is included and made a part of the lease.
Okay. That was the question. If all of those bottom things
all
that needed
21 pages should be initialed by landlord and tenant. Yes.
Okay. Thank you very much.
Yep. Other questions people have, Brett?
Nope, just hit the wrong button.
Oh, okay.
Good to see you, Sam.
Good to see you too. Other questions people have? I have one more form I want to share with everybody. This is the contract to lease. This is not a lease. A lease should be signed before occupancy of the property. I have seen realtors try to use this form in the past. I will tell you, don't use this form. But if you insist on using this form, it is available. It is a contract between the landlord and the tenant to enter into a lease in the future. And you'll see here, I've highlighted a few sections. The tenant will pay a deposit. Don't get confused. That deposit is for the performance under this contract to lease. It is not the lease deposit. The lease deposit information goes down here in this section that I'm highlighting now in red. So this is a very confusing form. It has a lot of blanks. It's a contract to enter into a lease in the future. I wouldn't use it. I would just enter into the lease when you're ready, because I don't know how you enforce a contract to enter into a contract other than to say that it does have failure to perform language. If the tenant fails to perform any of the promises in this contract, they lose the deposit. So I don't know why it's advantageous for any tenant to ever sign this form. It's certainly great for landlords who want to get into a lease in the future, but why wouldn't you just sign the lease now and be secure? So I don't know why this form is produced, but it is produced and it is available. All right. Other questions people have about leasing in Florida?
Sam, I have a general question.
Yes, Mona.
You don't have to answer it if you don't think it's appropriate. Some association intentionally make it difficult for rentals because they don't like rent.
Very, very much
Oh.
so. They do not like rentals and associations. They make it hard on purpose. Yes. Mona? Mona? I think we lost her. Other questions people have?
If you're using this form, I got lost. Why do we have to copy and paste? Isn't it already part of the form?
Because the form, notice what I showed you, Tina.
Yeah,
Let me go back down there. Notice what it looks like. It
yeah.
just says name, and it doesn't include any email addresses. You have to type in the email addresses and the names into the
Okay.
form and check these appropriate boxes. And when you go into Form Simplicity, for example, or one of your forms filling programs,
Yeah.
you're not going to be able to fill this in the
Okay.
form
Okay.
because there's no blanks provided. You have
Right,
to, you
right.
have to
I got
make
it.
the blanks.
I got it now. Thank you.
Yep, you got it. Mona, are you available? I don't see that she's
Yeah,
trying.
yeah. I don't know what happened. So what do you do about that? There is a law here in Florida?
Well, you cut out. Say your question again.
Yeah, my question is some association make it very difficult for
Yes, they
somebody to
do.
rent by raising the application fee from like 150, which is standard or normal, to like 450.
They
What
can
do
do
you,
that.
they can do that?
Associations have broad authority to set their own rules in condominiums and homeowner associations. Yes, they
So
can make
there
the
is no
application.
limit.
They can take away rental rights.
Wow. So there is no maximum for an application fee in Florida.
Not that I've ever seen. It's not certainly in any statute.
All right.
Joe, you're asking, how do you enforce an automatic approval if an association doesn't approve or disapprove in time for the service? I would send a note, Joe, an email to the property manager, say we are now on day 8. My tenant is a service member. He is deemed automatically approved, and we will be moving in on such and such a date. That's all you can do, because the CAMs, they don't respond, they don't listen, they don't pay attention. So you just have to force the issue, Joe. Other questions? All right, we are way over my 30 minutes time. It's been an hour and 15 minutes. So I'm going to say thank you to everyone today. If you have any questions in the future, please reach out to me at any time.
Thank
You know I'm available on my cell phone or email. I appreciate all of you coming in today.
Thank you,
And we'll
Sam.
talk again soon. Thank you.
Thanks,
Sam,
Sam.